Welcome back, everybody. Now, the Correctional Services Minister Ronald Lamola has halted the parole of convicted rapist Bob Hewitt. It comes after the department confirmed 79-year-old Hewitt would be released on parole next week. But Lamola says Hewitt's parole needs to be reviewed because there was absolutely no input at all from the victims when the Parole Board was considering the matter. Hewitt is currently serving a 6-year sentence for the rape and sexual assault of the 3 women in the 1980s and the 1990s. Well, Morning Live has extended an invitation to Minister Ronald Lamola, but his ministry said he would comment only after the process has been finalised. And joining us now is Justin Ramages, an attorney at TGR Attorneys, to talk to us about this matter. A very good morning, Mr. Ramages, and welcome to Morning Live.
Thank you. Thank you so much for having me.
Now, am I correct to say that the Correctional Supervision and Parole Board did not comply with the law in this matter?
Well, I don't think it's a question of compliance. I think it's a question of they have a procedure in order to execute on, depending on the time frame that you're allowed to apply for it. They applied their minds to it. Actual consideration wasn't given to the victims, and there we have a bit of a shortcoming. So as the process currently stands, they can make the decision, but it's still up for review, depending who makes the decision to pass it on to the Parole Review Board from the Parole Board, which the Minister did.
And I understand he served only 2 years of his 6-year sentence, which means he now qualifies for parole, right?
From a timing perspective, he is allowed to make an application, but the parties that have to apply their mind to determine if he is eligible for parole is the Parole Board. And there seems to be a bit of shortcomings, well, at least on the version of the Minister.
Yeah. And apart from good behaviour, what are the factors that the Parole Board bases its decision on, with particular emphasis on the nature of the crime and the circumstances, the personal circumstances of the offender?
Sure. And that's a very good question. I think Judge Bam, when he gave the initial conviction and the sentence, took all of those things into consideration. His age, the nature of the crime, the time period, and he made the judgment on that basis. Now, to claim that 6 years isn't sufficient time because of his circumstances, it seems to be a double fault in that instance.
Yeah. And where does medical parole come into the picture?
I think if he's suffering from ill health, if he's at risk of dying, I mean, he needs to be paroled to get key care if his life is threatened. But I don't think that is the issue here. I think the issue here is that due consideration hasn't been given to the victims of the crime, and the process needs to be reventilated.
So the parole process, Mr. Ramages, is it confined to offenders serving life sentences or just about any sentence?
So in addition to that, they have different categories of offences, the 0 to 5, 5 and up, and the lifers. And each of them have different categories and when you can apply for parole. And Chapter 4 sketches out the different types of parole that people can acquire depending on their application. But that depends on the application, the nature of the crime, the offence, the risk to the community. All of those aspects will be taken into consideration when the board applies its mind. But there's still a review process where the Minister or the Commissioner of Correctional Services or another interested party can apply to the Parole Review Board to say, listen, can you look at this again? We don't think the decision is right. And when the Parole Review Board reconsiders the matter, they can do 2 things. Either they can confirm the initial decision or they can suspend it and apply their own one.
So who's supposed to be part of the entire process? I mean, the parties involved, who are they?
So they are appointed in terms of the Act, they're creatures of statute. So ordinarily they have an attorney, 2 members of the public, people from Correctional Services, and they will reconsider the matter. I think it's actually not an attorney, a retired judge, and they will reconsider the matter. So there's a proper process. They'll get the application form, they'll get the review notes, they'll have a look at it, they'll look, has the process been followed, have they applied their mind, look at the old judgment and come to a decision.
So what's the genesis of the impasse in this particular case involving Bob Hewitt then?
So the impasse comes with a woman who still feels aggrieved, and she feels that her consideration hasn't taken into effect because while Bob Hewitt serves 6 years of a sentence he committed in the 80s and the 90s, these women have to live with it from the 80s and the 90s continuously. We don't know how it affects them mentally. We don't know how it impairs their ability to form relationships. We don't know how they sketch their life going forward. And it took them, I think, roughly 30 years. It was in 2012 where they started to make a noise about this whole affair, and still the man is 79 years old or 76, I'm not quite sure.
79, yeah.
But he is on, for lack of a better word, death's doorstep. And here you have women who still feel aggrieved, they still feel that justice hasn't been done. And that's why they want to put forward their considerations where they say, hey, take our views and our aspects into account when you make your decisions. I think that's only fair when it comes to justice. I don't think justice should discriminate when it comes to age.
So to what extent does the consultation with the victims stretch in as far as coming to the conclusion or making the consideration for parole? Does the parole board throw the gauntlet onto the victim?
I don't think they throw the gauntlet. They give them an opportunity to make representations. Put forward your case. Tell us what the problem is. Tell us what you want us to consider. And when we look at the accused and we look at the victims and we balance it out, we'll come to an appropriate decision, which we think represents justice in this instance.
But in this particular instance, so many victims find it very, very hard to heal. And, I suppose that most of them will believe that, no, they have been aggrieved in this particular instance and they will not allow the perpetrator or the offender to be granted parole. So can the parole board disregard their representations then?
No, they shouldn't disregard their representations. But that's why you have two sides of the story. You have Bob Hewitt putting his version forward, right, in terms of his application, and you have the representations made by the victim. And what you get is a decision taking into consideration both sides of the story in order to come to appropriate decision in the mind of the Parole Review Board.
So isn't the minister or the department involved in the consideration of a parole board? I mean, for the minister to now come up and say that he's halting the process because so many processes have been flouted.
Sure. So in terms of the act, it empowers the minister to tell the Parole Review Board, reconsider this matter. He doesn't take part of it because there's a split between executive and the administration. And what the administration needs to do, there's appropriately qualified people. Remember, the previous minister is not from a legal background. He's a politician that has been put in place to guide policy. But even he has legal advisors who probably advise him, listen, this is the state of affairs, this is what you need to do, these are your powers. I think, you need to make a decision. And on his contemplation and consideration of the matter before him, he says, look, I don't think there's appropriate opportunity given to the victims, and I think the parole board, who's more senior and has the power to reconsider the parole board's decision, I think they should take it on review, reconsider it, so we can see what is just.
So the minister has the prerogative of overturning and overruling whatever decision arrived at by the parole board?
No, he can't overturn and overrule. What he can do is refer to the Parole Review Board to consider. So there's the Parole Board and the Parole Review Board. Parole Board makes a decision. Minister or the commissioner or other interested party says, look, I'm not sure I'm happy with that decision. Please refer to the Review Board, who reviews the decision of the Parole Board. Sorry, the names are quite similar. So it's the board and the review board. I think that's the easier way to make a distinction.
Does this not cause distress to the particular offender? Because 1 minute he's been told that he'll be going on a parole, and then the next minute, then the parole is being turned down. And on the other hand, the distress caused on the victims themselves.
I think it is a stressful situation in general. You have the perpetrator who wants to be out or spend his last years in the open. And I don't know how he's come to terms with dealing with his crime. But you have the victim on the other side who's like, I'm not ready to forgive, and I don't think appropriate justice has been applied to the situation. And that's why you have an independent forum who considers both aspects and weighs them together and decides, look, what is appropriate? Feelings are feelings, but we're a society built on rules and laws, and it must be applied, irrespective of gender or bias when it comes to making a decision.
So this particular error, if I may refer to it as that, by the Parole Board's decision to grant parole to Mr. Hewitt, what kind of message do you think it's sending to women out there, women in South Africa, particularly those who find themselves in the midst of gender-based violence and domestic violence?
I think that's a good question, and that's why we have a review process. So if we have the initial process which didn't take into consideration all aspects which needed to be considered at the time being, there is a review process where people who feel aggrieved by the decision can take it on reconsideration and say, listen, what is the correct decision given the circumstances, given the victim, hear their story, hear the accused story, and then come to a decision. So I think the message could be taken one way, they've come short in their duties, but the other message is we have appropriate checks and balances when your minister is watching a case and he says, hey, listen, refer this, I don't think this was correct, is a very strong democratic feature.
And can the review board completely deny Mr. Bob Hewitt's parole?
Yes. So what happens at the moment, if it's taken for reconsideration, it's suspended. And what they can do is they can actually completely overturn the parole board's decision, or they can confirm it. We're saying, listen, the parole board got it right. But we'll have to see. They are the forum, they have the correct information, they have the appropriate qualified people and resources to make that type of decision. So we're going to have to wait.
And I guess the discussion now shifts to the roles of the judiciary in this particular matter. So if he really is aggrieved, can he take his matter up with the courts? Arguing that some of his personal circumstances were not considered in arriving at that decision.
Sure. That is always his prerogative. If he feels that there's been a decision by the administration which is unfair towards him, he can then take it on review and say, listen, these are the shortcomings in the application of the law. This is what they didn't consider. They didn't consider these factors, and it will go to the process. But that doesn't mean he gets out. That means the decision will stand until the court overrules it.
And the consequences of the parole board not complying with the law?
The parole board or the review board?
The parole board, yeah.
I think it's not a question of did they apply the law, it's maybe lack of consideration.
Okay.
And so it gets the consequences is it gets taken on review, which it did, and the risk is that they can overturn their decision, which they can.
Okay. So what if the process is lengthy to the point that it actually covers the full sentence?
It would be hard to imagine that it would, because it's a question of public interest, so they might expedite it. But should that happen, what can you do? That's the way the process runs. You can't jump the line. You know, it depends on resources, allocation of resources, and that's a risk he has to deal with. I mean, he could apply to the court for some form of relief, but it would be difficult because the process needs to run its step, and he'd be jumping processes if he did.
And how prevalent are such cases? Have you seen or heard of such
I'm not
cases?
aware of that, but that would be a very interesting state of affairs.
All right. Sure. Mr. Ramages, we thank you for your time. Much appreciated.
Thank you.
That was Justin Ramages, an attorney at TGR Attorneys, talking to us about the Minister of Correctional Services' decision yesterday to place Bob Hewitt's parole under review. And as I mentioned earlier on, we extended an invitation to Minister Ronald Lamola to comment on this issue. And, he said that he will only comment after the process has been completed. This is Morning Live. It is 9 minutes before 7 o'clock.